Um, Ladies and gentlemen, good afternoon. We're waiting for a few stragglers to join us. But while we're waiting for that, I just want to remind you of the subject matter of this talk. It's Rescuing Insolvent Companies, the basic toolkit. It's the first of a series of Monday talks that we're giving through various members of Terra Firma over the next few months. My advice to you today is not to bother taking notes, because in fact my notes are going to be available after I've finished this talk. So all you really need to do is sit back and listen. I've got quite a lot to get through in half an hour, especially as I would quite like to leave 5 minutes free at the end for questions. We'll see whether or not I actually managed to achieve that. So here goes. A little bit of introduction, just to remind us that the notion of rescuing insolvent companies isn't simply some abstract textbook thing. It's something in which all sorts of people have an interest. So obvious examples are shareholders. Shareholders don't want their company shares to become valueless. Employees, they don't want to lose their jobs. Creditors, they want to get paid. And so the list goes on. What I want to touch on briefly before getting into the real subject matter is the position of directors. As you know, directors' duties have been well established in the case law for a long time, but they were codified by the Companies Act 2006 in sections 170 onwards. I'm interested today in section 1721, which sets out a general duty by saying a director of a company must act in the way he considers in good faith will be most likely to promote the success of the company for the benefit of its members as a whole. But what we need to look at in conjunction with that is another subsection, section 1723, which says the duty imposed by this section has effect subject to any enactment or rule of law requiring directors in certain circumstances to consider or act in the interests of creditors of the company. And what this is getting at is a common law rule that tells us that when a company is either insolvent or approaching insolvency, the duties which the directors owe to the company are owed through the company to the creditors, not the shareholders. Now, that's been crystal clear since judgment came out in an Australian case called Kinsella. You'll find the reference in my notes. It's been confirmed for the United Kingdom in the Court of Appeal decades ago in a case called West Mercia Safetyware, and it was reaffirmed by two judges in the Supreme Court, Lord Hodge and Lord Coulson, in Jetibia and Bilter. Now, it's important, therefore, to remember that the directors have an interest in the affairs of a company in or approaching insolvency, because they have a duty directed to the protection of creditors' interests. That's the Companies Act. We must also look at the, at the Insolvency Act. Section 214 of the Insolvency Act 1986 is called wrongful trading. And it operates, I'll read you the exact language, it's a bit clumsy. It applies to, quotes, a person, quotes, if A, the company has gone into insolvent liquidation, B, at some time before the commencement of the winding up, that person knew or ought to have concluded that there was no reasonable prospect the company would avoid going into insolvent liquidation, and C, that person was a director of the company at that time. Now, if the section applies, the consequence I set out in section 214 is this: the court, on the application of liquidator, may declare that that person, that's the director we're talking about, is to be liable to make such contribution, if any, to the company's assets as the court thinks proper. And then there's a potential defense in section 2143, which says that the court shall not make such a declaration against the director or directors if it is satisfied that that person, once again the director, took every step with the view to minimizing the potential loss to the company's creditors, which he ought to have taken. And then, unsurprisingly, there are statutory provisions telling us, and also a fair body of case law actually telling us what a director knew or ought to have included and what steps he ought to have taken. But the point here is that if the directors are found to be at fault, the approach of the court is essentially to take two snapshots of the company's balance sheet. It looks first of all at the state of the company's affairs at the date on which the directors ought to have realized that the company was heading for the wall. And then it takes another snapshot at day one of the liquidation. And if the creditor's position has worsened in that time, for example, because net liabilities have increased during that period, then what the court can do is make the directors liable for that difference, for the increase in the net liability by sharing out the responsibility among the directors. So that is just perhaps a clumsy way of reminding you that the directors have an interest in the future of an insolvent company. Now, there has been this quite a common assumption, actually, that when the directors think that the company is getting into difficulties, what they must automatically do is stop trading. Now, it really isn't as simple as that. The fact is that what we would always advise directors, if they came to consult us, is that they should consult an insolvency practitioner. Now, the insolvency practitioner might actually say, yes, there is no way out of this. You've got to protect yourself and the creditors by stopping trading right now. But he might not say that. He might propose some form of corporate rescue. And that is really what I want to talk about, various forms of corporate rescue. There are various statutory underpinnings of corporate rescue, different mechanisms available, and some of those mechanisms lead to different outcomes, and some, it's fair to say, are more rescue-friendly than others. Now, I want to touch on just 5 of them in this talk, given the time available. First of all, liquidation. I have very little to say about it, but I must say something about liquidation. Secondly, administration. Thirdly, company voluntary arrangements or CVAs. Fourthly, scheme of arrangements. And then fifthly, moratoriums. So moratoriums do in fact overlap with some of the other ones. So what have I got to say about winding up? It's just to remind you that the purpose of a winding up is for the liquidator to sell all the company's assets and use the net proceeds of sale after he's paid his fees and all the rest of it, in paying off the unsecured creditors in whole, if he can, 100 pence in the pound, or if there's not enough money, pro rata to their claims. And that just reminds us that the key thing to take away from this, is that winding up is not really of itself a mechanism for rescuing the company. It's a mechanism for putting an end to the company and to its commercial activity. Now, contrast that with administration. The principal purpose of an administrator is not to put an end to the company at all. There are statutory purposes which are listed in Schedule B1 to the Insolvency Act, specifically in paragraph 3.1 of that schedule. And they provide that the administrator of a company must perform his functions with the objective of, and again, I'll just read a few lines verbatim from the statute. He must perform his functions with the objective of A, rescuing the company as a going concern, B, achieving a better result for the company's creditors as a whole than would be likely if the company were wound up without first being in administration, or C, realizing property in order to make a distribution to one or more secured or preferential creditors, a very restricted class of creditors, as you can imagine. But that's not the whole story, because paragraph 3.1 actually sets up a statutory hierarchy among these objectives. So in principle, the administrator's primary objective is to seek to rescue the company as a going concern. The company, the whole company, is a going concern. But secondly, second in the pecking order, if you like, if he thinks that that is, quotes, not reasonably practicable, he must turn to the second objective, which is to seek to achieve a better outcome for the company's creditors as a whole than if the company simply went into liquidation straight away. And only if he thinks that neither of those two things can be achieved can he turn to the third, rather unattractive objective, which is realizing property to distribute the proceeds to secured or preferential creditors. But even that third thing he can't do unless he considers that it won't unnecessarily harm the interests of the creditors as a whole. So the scenario I'm envisaging here is that an administrator comes into the company, he looks around, he thinks, oh gosh, I've got to think about rescuing the company, no, I can see this just not on. It's not on. All that I can do is try and get a better outcome for the creditors. As for the third objective, I told you we're not really interested in that. So let's think about achieving a better outcome for creditors. The legislation is not at all prescriptive about how this is supposed to be achieved, what shape the corporate rescue must take. What happens very, very often, and really you don't need me to tell you this, what happens very often is that the administrator, when he's got to know the company and its business, will identify or try to identify a viable part of the business which is capable of being hived off as a going concern, packaged together, transferred to a clean company, which is always referred to as NewCo, and then to sell off NewCo to a third party. And that will leave behind in the company a rump of the company's business, which is just not viable. Business and the associated assets, but with no commercial life left for the company to pursue. And so the company will go into liquidation. The rump business will go into liquidation, if you like. Then the proceeds of that rump of the business will be added to the proceeds of the sale of NewCo, and they'll form the funds available for a dividend to the creditors. Now, it can take some time, of course, for an administrator who's new to a company to analyze his business and work out what, if anything, has some prospect of being rescued. And during that time, the company will be at the mercy of its creditors, were it not for a very powerful provision in Schedule B1, which is the creation of an automatic moratorium, the effect of which, subject to possible intervention by the court, is to prevent creditors from attaching the company's assets or from winding the company up while the company, or from suing the company while the administration is on foot. Now, a little aside, some of you will be aware that quite often, by day one of the administration, the administrator has already spent quite some time in a pre-administration period crawling over the business and setting up with the directors and the financiers and other third parties a so-called pre-pack, in which all the documentation of financial arrangements for the transfer of a viable part of the business to NewCo and the sale of NewCo to the third party, all those preparations have already been done by day one of the administration. They're just waiting for the company to go into administration so that they can be implemented. Now, pre-packs have attracted over the years a great deal of criticism. And the main reason is this, that classically, the outcome of a pre-pack is that you get the viable parts of a failing company being packaged and transferred to NewCo. NewCo is then acquired by the very directors on whose watch the company had got into difficulties in the first place. And then those directors happily go on trading the new company, leaving all the old debts behind in the old company and leaving the creditors of the old company with nothing to show for this exercise, except for a dividend of so many pence in the pound. Now, because of repeated complaints in Parliament and elsewhere, the serious checks and balances have now been put in place to deal with this, with the potential for abuse here. They're set out now in SIP 16, Statement of Insolvency Practice 16, which actually has no statutory status. It's the Institute of Chartered Accountants of England and Wales that have produced this. Technically speaking, SIP 16 doesn't even apply in Scotland, but you can take it pretty clearly that any Scottish administrator or pre-administrator who is instructed in relation to a pre-pack will apply SIP 16 as if it did apply in Scotland. So that is, if you like, is one of the classic outcomes of an administration packaging the viable business together, sticking it in NewCo, selling on NewCo. But that's not all, of course, that the administrator can do. What he can do is propose to the creditors a company voluntary administration, or CVA. And that's really the next thing that I want to talk to. CVAs were created by the Insolvency Act, and the principal governing legislation is now Part 1 of that Act, Sections 1 to 7b. Once again, Parliament has not set down any prescriptive rules about what you can do with the CVA. There are limits. I can summarize them roughly like this. The CVA must be a, quotes, compromise or arrangement between the company and some or all of its creditors. Now, the case law tells us that that means that it must be a bit of give and take on both sides. When you look at the cases, it takes almost next to nothing to satisfy the give and take test. A CVA cannot, as a matter of law, prejudice the interests of secured creditors without their consent, and it cannot prejudice the interests of preferential creditors. In certain circumstances, there are things called moratorium debts or priority pre-moratorium debts. The CVA cannot compromise those debts. They form what is usually called rescue finance, and rescue finance enjoys a super priority. And then crucially, a CVA must not be tempted by procedural irregularity or unfair prejudice to one or more creditors. As a matter of fact, most of the case law deals with those two concepts. But back to my point again about Parliament not being prescriptive about what you can do with a CVA. You can really, subject to those restrictions I mentioned, you can do anything, propose anything. A CVA, for example, can cancel company debts. It can alter the rate of interest on debts, altering meaning here, of course, reduce the rate of interest. It can reschedule the debts, meaning, of course, have the debts repaid later than would otherwise be the case. And there's also a specific subset of very, very interesting CVA cases where the company going into the CVA, or proposing the CVA, is the tenant under a whole raft of leases up and down the country, under which it operates a whole raft of chain stores. And in a CVA for such a company, you can accelerate the termination of leases which are commercially unsustainable. You can reduce the rents payable. You can compromise the amounts payable for dilapidations. And you can even, this is perhaps the most astonishing aspect of the thing, you can even cancel guarantees for the payment of rent. And this is called guarantee stripping. And frankly, you can mix and match all of those things. So when we look at a CVA and ask, well, what's the difference between that and administration? Because of its flexibility, a CVA has a much better chance, if it ever gets approved by creditors, of rescuing the whole of the company as a going concern, even though the company's business will look rather different once the CVA comes into force. A company naturally can't impose a CVA unilaterally. It requires the consent of creditors and shareholders. The wishes of the creditors, obviously a proposal is made, the wishes of the creditor take precedence. So if, for example, you have the members accepting a proposal for a CVA, but the creditors rejecting it, that normally means the CVA simply won't happen. But the key point about all this is that if the CVA is properly approved by members and creditors, it binds all the creditors, including those who didn't vote for it at all, and including those who voted against it. Now, contrast this with the difficulty with which the company or the administrator would be faced if what they were attempting to do was reach discrete agreements with each and every one of the creditors. I said I was going to, well, I'm saying now, rather than I said, I want to avoid a technical approach to this, but there's one technicality which is important, and that is that in order to obtain this crucial approval of creditors, the company doesn't have to split the creditors up into different groups according to their various legal rights and get separate approval from each group. They're all lumped together. And that has the rather strange consequence where, for example, if you think of one of those landlord and tenant CVAs I just mentioned, you can have a landlord who under the CVA is going to have his rent paid in full and whose lease is not going to suffer accelerated termination, voting at one and the same meeting with a bunch of landlords whose rent is going to be reduced and whose leases are going to be prematurely terminated. Now, clearly, there's a possible exposure here to one group of creditors steamrolling another, but that danger is mitigated by the fact that a creditor may challenge the CVA on one or other of both the two grounds I just mentioned, unfair prejudice or procedural irregularity. And of course, the ultimate sanction is for the court to strike the CVA down. I'm now approaching the tail end of my talk. My next topic is schemes of arrangement. Until very recently, schemes of arrangement fell under what is now part 26 of the Companies Act. I may have wrongly called that chapter 26 in my notes, in which case, do forgive me, it should be part 26. There is now a new part 26A, which I'm not going to discuss today. It is headed Arrangements and Reconstructions, Companies in Financial Difficulties, clearly something in our target area, but it's a subject all to itself. And I'm going to talk about that, if anyone has the will to come along and listen to it, in my talk in December of this year. Let me just whet your appetite by saying that a Part 26A scheme is referred to in the trade as a restructuring plan, or even as a cross-class cram-down. So that's what's in store for you if you come back to listen to them all in December. But I want to put that to one side now and skim quickly over the surface of what I call a classic scheme of arrangement of the Part 26. The history of this legislation is quite interesting, actually. When it goes back to Victorian days. When the legislation came into force, a creditor scheme could be proposed only by the liquidator. And that meant the company had to be in liquidation. And there were no member schemes at all. So you could have only a creditor scheme, and the company had to be in liquidation. Then that was slackened in two ways. First of all, it became possible for a company to propose a creditor scheme without being in liquidation. And then finally, we had member schemes attached as well. Here again, there's a rule about there being some kind of give or take in the proposed scheme, but subject to that, and subject also to an important point that a scheme cannot affect people's proprietary rights. It affects generally contractual rights. There's no limit to what you can achieve. I don't want to dwell here either on procedural matters, but there's one general procedural point I need to make, and that is that the procedure for these schemes is in two stages. First of all, you have a petition in which the court is asked to direct, or at least to permit, the directors of the petitioning company to convene meetings of creditors so that their approval can be sought. And approval requires at least one half in number, representing 75% by value of the creditors who vote, not of the creditors as a whole, but of the creditors who vote. And then assuming that is achieved, and then the report of the meeting is given back to the court by the chairman, you have a part two of the application, which the court is asked to sanction the scheme. And then, of course, by that stage, the court will make an order to advertise the petition and give people a right to lodge answers and that sort of thing. The point about this is that if the scheme is sanctioned, it once again, rather like a CBA, binds all the creditors to whom it applies, even if they voted against it, or even if they didn't vote at all. There's only one thing I need to mention, I think, before passing on to moratoriums, and that is the fact that the statute refers to creditors or classes of creditors. Now, any of you who've ever advised a company proposing one of these schemes will know that it is a continual headache for advisors dealing with this issue of classes of creditors. Parliament hasn't told us what is meant by a class. There's a very useful summary of the law given by Lord Miller, sitting actually on the bench of the appeal court in Hong Kong, in a case called UDL. You'll find that in my notes. And what he said was this: the question is whether the rights which are to be released or varied under the scheme, or the new rights which the scheme gives in their place, are so different that the scheme must be treated as a compromise or arrangement with more than one class. Persons whose rights are sufficiently similar that they can consult together with a view to their common interest should be summoned to a single meeting. And that stresses, of course, that the emphasis is on rights. It's not on interests. People's interests will be considered by the court when it comes to the final hearing to decide whether or not to sanction the scheme of arrangement. Now, the class thing is I said it's a headache. It's a headache for two reasons. First of all, if there must be two classes, the practical effect is that each class of creditors has a veto on the scheme. It's all or nothing. You can't have, well, you could have a clever scheme, which became different sorts of schemes according to who voted for it. But in principle, all the classes have to be on board. But secondly, and this is crucial procedurally, if the company fails to split the creditors up into the appropriate classes and to hold separate meetings for them, then the requirements of Part 26 will not be satisfied, and the result is the court will have no jurisdiction to sanction the scheme. And that is, of course, an expensive error to make, and it has been made in numerous cases. Now, I've got a little bit in my notes about compare and contrast between CVAs and schemes, but I want to pass on rapidly, if I may, to moratoriums. I mentioned something to do with moratoriums already, but the point is this: if a company hasn't got a moratorium, for example, because it's not in administration, the mere fact of it announcing that it's thinking of proposing a scheme to creditors could lead to a stampede of creditors wanting to attach assets and wanting to enforce this and that contractual rights or withhold performance of this or that. So what is needed is some form of moratorium for companies which are not being bound up, not in administration. And Parliament has provided twice for that. We have the old legislation, which is enforced until very recently, and the new legislation. The old legislation was unsatisfactory in at least one way. In order to have a moratorium, the company must be an eligible company. And originally, an eligible company was an SME, a small or middle-sized company with a limited balance sheet total. I think it was £10 million. And so in fact, the moratorium just wasn't available to large companies at all. That was a big drawback. The new approach, created by the Insolvency Act, in fact, is by insertion of new wording by the Corporate Insolvency Governance Act 2020, is to provide that an eligible company is any company at all unless it belongs to an excluded category of other companies, ineligible ones, which typically are insurance companies, banks, and other sorts of financial institutions. The other drawback with the original moratorium legislation was you didn't get it all, it wasn't easy to get. The directors had to apply to the court. Now, you don't need to apply to the court at all for a moratorium, one of these moratoriums, unless there's already a winding up petition pending against the company. But if there's no pending winding up petition, you get a moratorium simply by filing the papers at court. Now, I give a little hint in my notes about what some difficulties might be with this. I also end with a few facts and figures. I won't read them out in detail to you, but what we see is that although the Insolvency Service kidded itself for some time, administration was going to become the high road for corporate insolvency, it hasn't happened. Administrations are very much a poor relation in relation to creditors voluntary winding up. CVAs are even fewer than administrations. In the 3 months from 3 months of July, August, September of this year, there was only one CVA in Scotland. Those figures, of course, tell us nothing about cases where the CVA was proposed but simply wasn't approved by the directors. So that, I'm sorry that was such a rapid canter, perhaps it was a gallop rather than a canter, but it does leave me, I think, with a few, well, it actually leaves me with minus a couple of minutes, but subject to people's tolerance, I'm quite happy to attempt to answer questions if anybody wants to signify that they have questions to answer.
Just to confirm, that would be by the question and answer function.
Yeah. And will I see something at the bottom of my screen, Susie, if there's a question? I'm sorry, Susie. I'm saying Emma. In fact, I thought.
Yes, you would.
Susie, my wife, I beg your pardon. There'd be a hand raised, a red hand raised or something.
There would be question and answer.
Okay,
it would pop up.
yeah.
But it appears that people might not. But if people do have any questions, then we could put it to us at a later stage, I'm sure.
Okay. What I can say right now is that in my December talk, I'm going to have another canter again through the classic Part 26 scheme of arrangement, just to use that as a backdrop to the new Part 26A scheme, which is deliberately conceived as a rescue mechanism. So that's what's coming in December. I think it sounds as though all I need to do right now is to thank people for having the interest to come along and listen in the first place, and then thank them for having the patience to hang on and listen to me until the bitter end, if indeed that is what they have done. And as Emma said, if there are questions, I can deal with those later. And as I think I said at the beginning, my notes can be obtained. I think Emma will indicate how that can be done. So once again, thank you all very much.